My name is Joel Schumacher. I work for MSU Extension. I'm an economist by training, so I come at this sort of from that side of things. There's some other ways you can think about estate planning and some of that kind of things, but we're going to come at it from the angle I have. And I work a lot with Marcia Getting. Have any of you ever seen Marcia Getting present? Yeah, so she's a colleague of mine. She's next door to me in the office, and sometimes she does some very similar talks. And in fact, Marcia and I have written, I don't know, mostly Marcia, but we've got maybe 40 different Mont guides, which are like 2 to 8 page guides on, you know, what to do with your IRA, how to write your will, where to put a letter of last instructions. And they're all listed on the back of this. I didn't bring them all with me because I hate packing 5 boxes of things to give out 6 Mont guides. So if you want to take one of these with you, they're all available in PDF form on the internet. If you don't have that, stop by the county extension office, which is over Upper Reserve, and they'd be happy to get it for you. Or call our phone number, which is on here, and we can mail it to you. So that's why I brought basically these. The other thing that I'm going to mention is 2 websites, and there's business cards for both of these. First one is Dying Without a Will in Montana. About 5 or 6 years ago now, we created a website that lets you put in your particular family situation, and what it'll do is tell you what the state law will do with your property if you do not have a will that would direct it otherwise. So there's the website. If you don't have internet access, the phone number on here, and we can mail you a CD that has the exact same sort of little program on it. But you click, I'm married, I don't have kids. Or, I'm married, I do have kids. And it lets you, it'll give you a diagram then of what would happen. So that's this one. The other one I'm going to put up here is one of the main programs I run is called Solid Finances. It's a web-based series where we teach 1 hour, 12 to 1, most Wednesdays during the winter, on different finance-related topics. So it might be estate planning, it might be retirement planning, it might be money management, it might be IRAs, it might be repaying student loans, all these different things. And then it's free to participate. Register, sign in from any computer with internet access. We also put all the recordings there of past ones. So if there's a particular estate planning topic that you're interested in that I'm not covering today, or you want to hear it again, chances are under the recordings of our old ones, we've got an hour-long session on it. There's probably about 65 recorded sessions there right now. After a couple of years, we take them off and replace them with updated ones. Sometimes things change, or sometimes we've done a newer one, so they're not there forever, but those are free and available to you. And if you don't have access, most of the librarians in the state have been trained to help people find these as well. So if your local library is another place you can get those. So maybe parts of estate planning. We're going to talk about particular tools. For those of you that have heard Marcia, she sometimes does 2-day-long, 8-hour workshops to cover the material she has. We have 75 minutes. We're not going to cover it all. So we're going to hit some of the, I'd say, the broader pieces, the key points. Recognize there's a lot of things we're not going to cover. Some of them are covered here. But hopefully maybe it directs you to some things that you might want to focus and learn a little more on in the future as well. So I think I have a picture of the last generation of these that I have up here. I'm going to ask some questions, and I'm going to have folks vote. And all you need to do is push 1, 2, 3, 4, whatever matches up. And you'll get a little green light on there. If you push it down, I think it'll be red. And that means you voted. And then we'll show some results. We'll do a practice question here. All right. So how many years have you lived in Montana? And you should get a little green light to light up when you put that on. If it doesn't say like 4D or 3 or whatever in your little window, let me know and I'll give you a different one of these. And you can vote more than once. It's only going to take your last answer. So if you forgot how old you were, and ran out of fingers, okay. And then that's what it's going to look like. So I'm never going to know what you answered, so feel free to answer honestly. And if you got it wrong, it was probably the guy next to you. Yeah. Or do we want to pick
So is this today? I mean,
that's the results you guys just did. Yeah. So we got no newbies here. Everybody's been here at least a decade. And just about most of the folks have been here over 30 years as well. So, okay, just a practice question. So let's do one more here. This one isn't practice, but do you have an estate plan? A couple more people haven't voted. See, I can tell how many have voted. I'd say it's Ben that hasn't voted.
That's the same as
No, you're
oil.
gonna vote twice.
Is that the same as
Well,
oil?
so we didn't define estate plan.
If
That's
I
a good
vote
point.
twice, do you get another response?
It only takes your last one.
I already voted.
All right, so somebody's not voting, but that's all right. You don't have to,
So,
but
does it matter if it's the same?
it's okay. Whatever you want to take it as. We'll talk a little more about that. So. Okay. Okay. You all have an estate plan. The minute you were born, you have an estate plan. State legislature has put one in place for you. If you didn't pick, they put some rules out there that will direct that property for you. So you have one, but the question is it the right one? And do you need to make some changes to the one you have? And maybe the answer is no, maybe it's yes. That's one of the things we're going to talk about. Okay, one more question, then we'll get into some of the content. How many Montanans paid an inheritance tax in 2015 for folks that passed away? How many people do you think paid inheritance tax? What percentage? 100% of people that got property or assets? 0%, something in between? I got some work to do. 0%. Montana has not had an inheritance tax.
Hardly anybody.
Well, so I think you're thinking of my next one. So inheritance tax, we haven't had an inheritance tax since 1998 in Montana. So nobody's paid any in almost 20 years. Okay? State of Montana got rid of it, and there's no federal inheritance tax either. So if you get money, it's yours, right? Free tax base. Okay? All right. Everybody answering slide. Okay. So let me ask you a slightly different question. So this might be kind of to you. Do you think you or your estate is going to pay an estate tax when you die? And this is whether you think it applies to you. There is one, I will tell you that. Okay. Oops. Okay. I don't have any yeses, I got some maybes. Oftentimes, this is the thing you hear most about when you talk about transfer. The death tax, the estate tax, the government's going to take my money, right? That's what we hear about. You go down to the coffee shop, that's what you hear about. So there is a federal estate tax. It's a tax against the estate. So the estate pays it before it gets to the beneficiaries. So if your dad dies and gives you money, it's paid at the estate level before you get it. So when you get it, what you get is yours. The tax was paid at the estate level. So right now in Montana, and this is a federal law, basically, it's complex how you get there, but the first $5.45 million of your estate is tax-free. So if your estate is less than $5.4 million, no federal estate tax.
Did that just go up?
These are the rates it's been for the last 6 years. It's adjusted for inflation, so you'll see it slightly ticking up. If we went back to 2000, maybe 8, that number used to be around 2 million. That was 1.5. So it had a significant jump. I forget the year, but it was about 10 years
I
ago.
thought it was only a
Yeah, at one point it was in the 90s, and then but they lowered the top tax bracket, but then raised this level a few years back, so it kind of balanced, but it did it differently. But so what this really means is, most people aren't going to pay an estate tax, right? And let me make one more example here. It's also what they call a portability thing for married couples. So if you're a married couple, it's now possible to save essentially the $5.45 million of the first spouse that dies, and the second one can use 2. So that means they can pass 10.9 million. Now that was not always the case. There used to be a lot of other games you had to play to sort of take advantage of that tax thing. They've made it much simpler now. You file a form that says, yes, I want to save my deduction for my surviving spouse to use when that first one dies. It's that simple, as long as you file 704. So
You have to do that before or after, right?
it's actually, so let's say the first person dies, it's when you are filing their final estate tax, so they have basically a tax return in that final year, and you put an extra form in. It's a 704 that is honestly a super simple form, and you just basically put, I want to save my credit. I don't know any reason why you wouldn't save your credit. There's no downside to it. So it's just added to your return, and then when the second spouse passes away, at whatever point, they can say, okay, now when they're settling that estate, we've got the one credit for the current spouse that died, and we saved this one from over here. So, used to be much more difficult to accomplish that same thing, and there was a lot more
Do that
stress.
in like 6 months, right?
No, just when you file the return. So, yeah, just when you're doing your normal final return. And if you've got an attorney or or an accountant helping with pieces parts, they'll be familiar with this. So I want to go through, this is that form 704 is the number, serves as that portability form. And again, that allows it to carry forward. I want to run through one number example and then we'll move off of this estate tax piece. So the way it actually works is they charge the tax, but then they give you a credit for it. And this applicable credit is what would pay the tax on that $5.4 million. We could spend a lot more time, but I'm guessing most of you don't care. But at the end of the day, these two credits are what allow that to happen. So the way it would work in terms of a estate is, let's say we did have an estate of $10.9 million. Marital deduction is something I always put on there. You can always give as much money as you want and always have that to your surviving spouse. There's no tax implications. So if I died tomorrow with $100 million, I could give it all away, and there's no tax implication. That's always been the case, and that's this marital deduction. So we won't worry about that, but we'll just say that we have a taxable estate of this. So this is our tentative estate plaque. So there's a chart you can go to figure this out. It's in the Mont Guide if you want more detailed things. But if you had this $10.9 million estate, this is how much federal estate tax you would owe. But then you get to use your credit, and then we saved the credit from dad dying earlier. And the amount, so you subtract those, and the estate tax we're going to pay is 0. So that's kind of the methodology of how that works.
Now, that's the federal system. Does the state have?
The state has no estate
No
tax.
estate.
So this is it. There used to be a reciprocal agreement where the state kind of collected what the federal rate was. That's not true anymore. So this is the one and only estate tax piece that you have to worry about. And there's no inheritance tax. So that was the state one. So since I'm guessing there's probably more interesting things than something that may not affect a lot of us, and if anybody has more than $10.9 billion, I can give you a whole list of charities that would love to help you out. Right? Okay, so now that you know a little bit more, do you think the state will pay estate taxes? Okay, good. I don't have any more slides on the estate tax. So we can all think about things that are more important. That's what it is. Okay, like I said, it's on the
How do you know
list.
they're not gonna change the rules?
So that's, yeah, so that's a good question. Right? Congress can change the law at any point, right? If they could ever agree on anything, they could change it, right? So it's certainly a risk always, right? Yeah, there's no guarantee that this particular policy will stay in place for one day or 20 years, right? And I don't know of any particular way that you could hedge against Congress, right? But yeah, this is current law today, and as far as I know, there's nothing currently being discussed in any level about major changes to the plan at the current moment. But okay, so we're going to talk about some of what I think is a little bit more important. So we're going to start and talk about some contract law and how that fits in. And then if we have time, we'll kind of do some wills at the end. We're not going to get to trusts today, but we'll start with this because I think this is probably the most important thing. So, okay, so there are 3 types of property ownership in Montana that are not corporate related. So we have sole ownership, we have joint tenancy with right of survivorship, and we have tenancy in common. So let's go through a couple examples and we'll see how these pieces parts fit into what happens to your property. Okay, so how many of you, this could be your house or your land, how is your property titled? If you've got more than one, just pick one. I didn't set it up so you could vote up more than one. Okay, so we got a mix and we have some corporate, yeah. And I'm not too surprised on tenancy in common, that's certainly the rarest type we have.
What is that?
So we'll get to it a little bit more, but essentially, tenancy in common is, let's say you own 120 acres of land, equally with, say, your brother, and if essentially you each own 60 acres. You don't jointly own the whole thing. It's probably the simplest way to think about it. We'll do some more examples of that here in a little bit, too. The other common thing with tenancy and common, it's a little different. Does anybody own any tribal lands? Be thankful. It gets very complicated, but that's probably an extreme form of tenancy in common, because there's a whole bunch of joint ownership issues, and you jointly own the whole thing. So, okay, so let's start with sole ownership. So property is in one person's name only. So I'm going to do a bunch of examples, and I'm going to draw some pictures up here, and we're going to decide, you're going to tell me where the property goes, and then we're going to see how we do. So we're going to say we've got 5 siblings at this generation right here. These 2 sisters passed away in the past, and now we're going to say this bachelor brother passes away, never married, no kids. What fraction do you think this brother is going to get of his estate? He's got no will. Okay? So tell me, how much do you think that brother's going to get? The one with the little lightning bolt on it. Remember, it's this brother that passed away. So, is he going to get all that property? Is he going to get half? Is he going to get a quarter? Or is the state of Montana going to get it because he doesn't have any kids and no spouse? Okay, everybody got their vote in there? Okay. 38% of you got it right. So you can all raise your hand and say that was me, right? Yeah, okay. So let's put a concept. This is called right of representation. So essentially what it did is it got divided equally at this generation. Now, these 2 are passed away, so it went to their heirs, which in this case was their kids, is how that went. Okay? So, the state of Montana is only going to get property if they absolutely, essentially cannot find an heir. Right? If your second cousin's third brother's, dog died, right? They're going to find you and give it to you. If they can't find anybody, that's when it goes to the state. So there's very little chance that the state's going to get your property. Might be a relative you've never met that's so shirt tail away, right? They will track you down and try to get that property.
With no will at all.
With no will. So it is possible that the state can get it. If they can't find anyone, then your property would revert to the state of Montana. But that's, I don't have a number on it, but I would doubt that it happens more than once or twice a year. Right? And it's probably not a big amount. But
Who does the looking?
who does the looking? So that's a good question. So normally when a person passes away, the court appoints what's called a personal representative. You may know that as the executors is an old term for the same thing, right? And they're the ones that handles all the things, says, okay, this car, yeah, that's going to go to Bill, and they get the title over to Bill, and they do all those things, right? So if it became to the point where there was no one to step up and be, so the personal representative could be anyone. So it could be your next door neighbor that's helping you settle your estate. It doesn't have to be a family member. Right? So it could be an acquaintance steps in and says, well, you've been, but I don't know any of his family, but they could go to the court and say, my neighbor Ben died, I knew him, I want to be personal representative, and then they're in charge of distributing it this way or tracking down heirs of the property. So you can nominate a personal representative if you've got a particular person you want to do it. And then what almost always happens, the court has to formally appoint it. It's not like a court case, you go to the court and do it. But they just about always follow that recommendation. In fact, I've never heard of a case where they don't. But you could say, I want my daughter Jill to do it. And you can put that in a will, and Jill, after you pass away, walk in and say, look, court, Dad died, he nominated me, will you make the appointment of me? And yes, they always sign off, right? The only time I've heard of anything else happening is when there were 2 different people nominated.
Right.
Or maybe you nominate Jill and Jill says, I don't want to do it. The court can't force somebody to be your personal representative. So you can also hire, especially in more complicated cases, trusts can sometimes do it. Some banks have some people, attorneys can do it. You tend to see that, when Warren Buffett asks, he'll probably be a professional.
I was going to tell you I have a bad story. My father made me the executor, and my sister concluded that I was not doing a good job, and took me to court. And the judge ruled for sister.
Okay.
And so my other sister and I quickly hired attorneys and jumped into court and litigated away, and finally we won. But it was scary.
Yeah, I've heard this saying a number of times, you don't know somebody until you've settled an estate with them. Yeah. Yeah, no, I mean, it can certainly be a challenging position. And you can certainly have people that are unhappy with the process or feel they're being slighted, and hopefully you don't, but it can end up in court like you just mentioned. So. All right, let's continue on here a minute. Let's talk about a married couple, but we're still going to talk about sole ownership. So we got John and Mary, a couple, but the property is in John's name only. Okay. I think this is a situation we've certainly seen. Either they acquired the property before they were married, or maybe it was family land that was from John's parents or something. You know, we've seen that a number of times. And we're going to say they have no children. Okay. So we're going to say John dies in an accident, and Mary's with him. She survives the accident, but dies 3 days later. And these are all made up, so we don't have to feel bad for my people, right? But we're going to teach some concepts with these, right? Okay. So John dies immediately, Mary dies 3 days later. Who's going to get that property that's in John's name? Is it going to be John's relatives? Mary's relatives? State of Montana, or are we going to give it to the U.S. government? They have no kids. Okay. Okay, somebody that did John's relatives. Why John?
I don't think she stayed alive long enough. There's a limit, but I don't know what that limit is.
Anybody that voted for Mary want to say something?
Surviving spouse.
She survived him, so she got it. Okay, it's going to go to John's relatives. And you're right over here, that's why. So to be an eligible heir in Montana, you have to survive by 120 hours, which is 5 days. So what this gets away from is, you know, like a common car accident, somebody died on the scene, somebody died and ran to the hospital. We're not settling 2 estates on this 20-minute difference, right? So 5 days is what the legislature thinks. So you have to survive by 5 days, or you're considered to be predeceased of that person. So she didn't live 5 days after. So the way the court looks at this is the same as if Mary had died 10 years ago. She is not an eligible heir at the time of this death. Okay? Okay. So now, John dies first, Mary dies 6 days later. Okay? So now who gets it? Mary's relatives, because she passed that 120-hour requirement. So now she's an eligible heir. John dies essentially in this 6-day period. Paperwork was done, all the property transferred to his wife, who would be first in line with no will to inherit your spouse's
I'm
house.
curious, what is considered a common law marriage? How long?
We have a new Mont guide on that. We have a brand new Mont guide on that.
Uh-huh.
I don't know if it's on our list, it might be too new.
Because I have a friend whose partner just died last week, and they've been together for 17 years. And he has property where I'm at, and then she had a separate house in town, but they've been living together off and on. I mean,
So there's a whole list of requirements, and some of it that you present yourself to the community as a couple and things like that.
yeah.
And there's a whole checklist of things, but that's why we put it in the Mont guide, because there was a lot of little things, but.
Because I was just curious, he's supported her, he's saved her life numerous times, but he's not on the deed of the house in town. He has his own place.
Right.
So I'm curious, since he's staying in town until they sell the property, is he going to get anything out of that, or?
Montana does recognize common law marriages if you meet the criteria.
Yeah.
And there's a list of specific criteria.
Will he have to do something to present himself, or if he just doesn't do anything, is it just going to go to her
He's
relatives?
probably going to have to make a case to the personal representative or the court to state that he is.
So if he wants something, he is going to have
Probably,
to
yeah.
do something.
Yeah.
If he doesn't care, then it's just going to go to her family.
Yeah. And he should probably, I mean, if he's concerned that it might not go, I mean, now's the time to visit with an attorney or someone to get some
Yeah.
advice to see if he qualifies. I mean, if he wants to be qualified and if he is qualified.
Yeah, he's in a state of despair. I mean, you know, she just passed away.
And that's one thing, we'll talk about, if you're in a situation like that, and you know that in advance, if we're not legally married, we might not, that might be a good opportunity to write a will, or to do some things with property ownership that would negate the whole issue of whether or not you're married, that, you know.
Yeah.
So we'll talk about a couple of those tools, but anytime you've got, I would say the state of Montana's general rules for property distribution do a really good job for most people that have a traditional family structure. Married, kids, all from the same two people, no stepkids, no ex-wives, no, any of that. Once your family starts to get more complicated with adopted kids, step-kids, second marriages, things, then the state of Montana rules oftentimes don't work quite as well. Right? So those situations especially, oftentimes it's really beneficial for you to step in and do some of your own things. Make sure that it matches with your situation. Are my kids and the stepkids, have I treated them equally? Do I want them equally? Those kind of. And we'll go through a couple of those examples here.
You've been giving examples of property. What about non-property? Does it relate the same way?
Yeah, so what we're starting with right now are things that's called real property. It has a title. So all these things have a title. Your car, your land, bank accounts, all those things have a title to them. But you might have artwork, guns, furniture, things you think are valuable that don't have that, right? So one of the things you can do in a will is write a will. You can handwrite it if you want, but you can put in a list of personal items. And you can say, I want my 30-06 Winchester to go to Sally. And you put in your will that you have this list, and then that's all those personal items you have that don't have. We've heard stories, right, of people that, okay, well, the artwork, I told all the kids when they were here last time to put their name on a sticky note and put it on the back of the, right? But then we've also heard later that, the kid with the key came in and moved all the sticky notes around. Right? I mean, those things, you always hear these stories, so I'd recommend doing it with the list as opposed to. Okay, so in this situation, I guess the point would be that I think John and Mary probably need to write a will if they want, because they probably don't want your assets distributed based on who lives longer on something, right? So that's a good opportunity for them maybe to write a will so they can have a little more direction over where that property goes, regardless of who passes away first. Okay, so let's do another one here. So let's now move over to, we're going to go to Jim and Sarah. They have some property in Jim's name and some in joint tenancy, and they've got 3 kids. Okay, so another married couple. Okay, so here's our situation. So let's now say that they've had 2 of their children have already passed away, and now they die. We'll assume they die together, so that's fine. All the property's going to distribute. How much is this grandchild going to get if Grandma and Grandpa's stuff? Okay. How much is that one going to get right there? They're going to get a third, a sixth, 1/7, 1/9, or are they going to get none? Okay, it's a great chance to vote. All right.
Too late.
Okay, that's all right. So we got varying amounts here, right? So let's take a look at it. So if mom and dad passed away and there were just 3 kids, we'd all split it a third, right? That makes sense to everybody? Now I had that a couple of these kids had already died, right? So if this son had passed away, his, I don't know if that was son or daughter, would get the share that dad would have got. So that third moves on to that grandchild, okay? So let's change it a little bit. Let's say that now this one's passed away too. Now these 2 are going to get 1/6 because they're going to share the third that their dad would have got. Okay? So that 1/3, 1/3, 1/3 is still intact. It just then got distributed down. These grandchild are going to get none. Which grandchild do you want to be? Over there, right? Okay. Change the story a little bit else. If this one had passed away first, and here's the example that I asked you about, it'd be 1/9. Because they would get the share that their mother would have got, but there's 3 of them, so that 1/3 gets split 3 ways, okay?
That was kind of hard to do. I mean, it was arithmetic, no calculator, and,
So if you got it wrong, you can just say it was bad and they got it wrong. As long as somebody got it right, you can all claim to be that person. Okay, so this principle is called right of representation, okay? So that's where the grandchildren are getting what would be their right of the next generation, okay? Let's do one more story here on this. What if all the kids had died first? Now it changes. Right, so it's not 1/3, 1/6, 1/6, and 1/9 anymore. Now we're at 1/6. Why is that? Yeah. So it divides equally at the first generation in which there's a survivor. So there's no survivor in this generation, so the first generation with a living survivor is now this one. So now it's equal at this level. Okay?
It's kind of weird.
There's some other terms. You may see the term per surpice, which is essentially this as well. So just some other ways to think about.
How do you spell surpies? S-E-R-P-E-S?
S-E-R, it's a different word.
Oh.
Or P-E-R. Makes it S-E-R. And so if you see that, this is one of the things, you can certainly write your will yourself. You can do that handwritten, perfectly legal, you don't need any of that. What I think is a good idea occasionally with some legal advice is some of those terms, you can make sure you get the right language. Sometimes that's a value that, you know, an attorney or someone who deals with them on a regular basis can say, I know what you're thinking and here's the right way to write it. Right? And this will be one.
When you write your own will, you just take it to a notary and have them notarize it?
If you write it in your own handwritten thing, you don't even have to have a witness. If you type it, you get a witness. Okay? And we've got a Mont guide on that lists what makes an eligible will, how to revoke old wills, those kind of things. Yes?
Back to this lady's original question, are you equating a will with an estate plan?
It can be part of one.
Right, but in this case, when we're going through these, so.
You know that. So what we said here is there's no will in place. So because we're dealing about the next piece that we'll get to it in a minute, but this is the contract law we're dealing with right now. And if you have a contract law applies. So now when we're talking about, you know, your gun collection, there's no contract. So that is a different subject.
I didn't quite follow there. If I type my will and then sign it in my own handwriting, does my handwriting count? No. Really?
Now, you can get it, have witnesses and get it notarized, but it's perfectly fine. Type it up.
Just say, show my signature doesn't work.
Whole thing handwritten, and then you need no witnesses. If you want to type it up and just sign it, then you need to have some witnesses. Okay, any questions on sole ownership? The only one
One more question on that.
Yes.
It's a witness as opposed to a notary.
You can do both. You can have witnesses or a notary. And we've got I have one of them here. I brought one packet with me, which is most of our common ones, which is about probate and the wills and things. But we list out a couple of those things so we can double check a few of these things when we're done here. This is also a packet you can, this is just a collection of most of the common things that are on the back here. So if there's any of these you want, I have a phone number on you can call, and you get to my secretary, and she can mail them out to you, or you can print them off the computer. They're PDFs that are at this website that's listed right here. So we're happy to get that to you at no cost. I didn't bring a bunch with me, but. Okay, let's talk a little bit about joint tenancy. It's good we have questions. We probably won't get as far, but that's good. Okay, so this is a method of co-ownership of real property. So do you have property in joint tenancy? This could be land, could be your checking account. Have anything in joint tenancy?
Can I ask a question about me? My wife and I have some kind of a trust that I don't understand very well, and my wife died.
Okay.
So I'm not sure what I am.
Okay. Did an attorney help you set it up? It might be a good chance to have, to visit with your accountant or your attorney to see if, one, you can verify what the current status of that property is, and to see if there's any paperwork you should be doing now that will ease the transition for you when you pass on to the next generation too. Right. So this is, you know, anytime you have one, you may have a estate plan in place, okay, now mom passes away, it's just dad. That's a good chance for dad to take a look at his plan too, to see if there's any new situations that have come up, because obviously we now know a fact that he outlived mom. And there might be some things you might want to do a little bit in terms of that. So anytime you have a major life event, good time to review your contracts, any beneficiaries, wills. Those
Cut
kind of
out the
things.
stepkids.
If one of those kids is, didn't come for Christmas this year, Okay, so most of us do, this is probably the most common type for, especially married couples, this is the common type of ownership in Montana. Doesn't have to be within a family, right? Me and my friend could own property with joint tenancy, and my brother could, right? Okay, so we're gonna do some things. So we're gonna have a blended family here. So we've got a husband, and he's got 2 kids, but they're from some previous relationship, and we're gonna have mom, and she's got 2 kids from some previous relationship. A lot of families like this in Montana, right? Okay, joint tenancy. So, dad dies, how much is child B gonna get? This is one of his kids, okay? Are you gonna get all of it? Are you gonna get half of it, a third of it, a quarter of it, or none of it? How much is that kid gonna get? Okay. Okay, 56%, you got it right. We're gonna get 0, it's all gonna go to the wife. Okay? Joint tenancy with right of survivorship. So the right of survivorship, she survived him. So all of that now goes to her name, okay? So now let's say mom dies. Right now what happens? So how much did child B get out of the whole deal? Is that what they wanted?
That's where the dad and wife really need to have a little, yeah, really need to.
So again, like I said, if these had all been their kids, the traditional family structure would have been a quarter to each of them, right? Which might be what a lot of families do. If you have a blended situation of any type, then those state rules sometimes don't match up near as well. All right, so, but let's change the story a little bit else. Let's say that mom remarried and put the property in joint tenancy with her new spouse. Now she passes away, where does all the property go? To him.
What if it's not joint tenancy?
Okay, so then it depends, right? So, was it sole tenancy? Right? And then you're going back to just looking at it like it was sole ownership and he had passed away. And there's the husband gets what's called an elective share. We'll talk about that in a minute. And then the kids would get some as well. These 2 kids. These kids, they get nothing. Because they're not linear descendants of this mom, right? That's a stepmom. Okay.
So
So,
what if they adopt or something?
so adopted children, that's a good point, are treated exactly like a biological child. So if you've been formally adopted, so if this was a stepchild, but then you formally went through the process and adopted that child, now it's just as if it was a biological child. Okay.
How about those separate kids of his that got left out? So do they have any claim to their biological, the other biological parent?
Yeah, so there's still a biological mother somewhere, right,
Yeah.
that isn't in this story.
So they'll have a claim to her,
Yeah, certainly possible.
her estate possibly.
Yeah.
I see.
Because they are still her heirs.
Right.
Yeah. So the main key with joint tenancy is that on the death of either owner, it goes to the surviving owner or owners. You could have 3 people in there, right? It could be 3 siblings, right? One dies, now the other 2 own it together. One more dies. Yes.
So is this only if there's no will, or it's always if you have joint tenancy and there's no way around it?
Contract law is going to override a will.
Oh,
So we don't go to the will if there's a contract law in place.
and if you have something titled joint tenancy, that's a contract and you can't override it with a will. So what if you did want to make sure that those other kids had some, how do you do that? Don't put it in joint tenancy.
Usually it's set up with, well, there's a couple things. One, you can change the type of, sometimes you want to change the type of ownership. Sometimes that's appropriate. Sometimes you write a set of dual wills for mom and dad. And then we're gonna talk about a beneficiary deed here in a minute, which is gonna be another tool that's sometimes used. So there's a number of different tools for different situations.
Now, bank accounts, you can do joint tenancy with ownership, and then you have a next layer
And a
of
beneficiary.
beneficiaries. So if that,
So I want you to save this question, because this is like a slide in. It's like I gave her quarters to ask me the right questions. So we're gonna come back to that, and if I don't, ask me again, okay?
but maybe going back, so the difference between joint tenancy and tenancy in common is that with joint tenancy, it goes to the owner who's joint, but with tenancy in common, it wouldn't all go to the other person.
Yeah, we would actually, if you had 50-50, the 50% of the person who died would be distributed according to their estate and tenancy in common, which is where changing a title sometimes might matter. And we'll do one example on that here in just a minute. So the main key with this route is death of anybody with the surviving owners is who's going to get their share. Okay, so another tool that again we're not going to touch on, but you can also do things where you create a life estate. So remember, this was initially solely owned. We could put this in sole ownership, and you could say, let's say, okay, this is the husband's family farm or forest land, right? We want it to stay in his kids is, maybe these two kids are the ones that have this tied to it, and less so these two. But he doesn't want to leave out the new wife. I mean, not like he was fighting with her, right? There was, So one of the things that can be done is you can actually give a life estate to the wife. I think I'm out of juice on that. Where she would get to live in it and use it for the rest of her life and get the income on it while she's alive. But then when she passes away, it's already pre-directed back over to the remainder here. It's a more complicated estate planning tool, but sometimes that meets everybody's needs, where we've provided for mom, but we still kept it in this side of the family if that's where this particular asset sort of belonged or something, right? Okay, so let's talk a little bit about joint tenancy with Tim and Sharon. So we're going to go back to our 3-day story again, right? So Tim dies first, Sharon dies 3 days later, and we had this in joint tenancy, right? So we've changed the story a little bit from before. So who's going to get this property? I
don't understand the question.
Okay, so we have the property in joint tenancy, and they passed away in a car accident. 3 days later, the other one passed away. Tim passes away first. His wife passes away 3 days later.
They don't have any kids.
No kids. Okay. If you get it wrong, you can just blame it on her, right? Okay, half to each set of parents. Okay, and that's exactly right. Because the 5-day rule didn't make it that far, so they're essentially treated as dying at the same time. Which state law will say if there's no will and there's no other thing, and parents are living and there's no kids, that it would distribute equally back to the parents. Okay? Again, there's the 120-hour rule is in place again.
Question on that. If one set of parents is dead and the other one alive,
So,
what do you do about giving something to the dead parents?
so right of representation would come in. So who would their heirs have been?
Well, I mean, like if
There
there
might
was
be
a sibling
other-
or something.
Yeah. So it would go essentially to the parents who have passed away's estate, which then has heirs to it most likely. Other siblings probably, other kids. And it would then distribute in that right of representation. So what would their share have been of mom and dad's estate had they been? So let's change it to the 6th day. Now it's all going to go to Sharon's parents because she outlived him by the 120 hours. So now that joint tenancy went all to her. And then she's the sole owner. Now she passes away. Now it goes to her heirs, which are her parents. Okay? Switch the story, and Tim lived 6 days. Now it's going to all go to Tim's parents. So the same ownership structure, and we could have it go all to his parents, all to hers, split between both of them. Right? So if they want to control what happens, this maybe isn't the best setup, right? To have only contract law in place. Okay?
But a will, if you had a will, then it would.
It could be, yeah. Okay, so let's do a couple slides on tenancy in common, and then we'll talk about some of these other tools we can add to the basic contract law to do it. Okay, and I think you guys already told me earlier, nobody had tenancy in common, right?
Actually, yeah,
Okay, you do, okay.
but not the winner.
All right, let's jump forward here to the next one. Okay. So tenancy in common, and if you're not exactly sure, take a look at the title and see what it says. If it says, you know, Joel and Tara Schumacher, joint tenants with right of survivorship, it's pretty clear. Or right of survivorship, or JTWOS, right? But if you see this, tenants in common, then it's very clear. Usually it is clearly labeled on your title if it's tenants in common or joint tenants. Okay? So look at your title if you're not 100% sure. But in this situation, let's say you got a brother and a sister and they've each got some kids. And they actually, this is actually a real story, this particular one. Grandma and Grandpa in this picture gave the family farm to them. And they directed it in the will that they'll own it as tenants in common. You can actually do that if you want. So now they own it this way. Right? So now we're going to see what happens to child B if the brother dies. You guys want to tell me how much you think that child B is going to get? So we've got tenants in common right here. Okay. And we got a quarter is what most people are telling me. And that's exactly right. So had it been joint tenancy with right of survivorship, it all would have went to the other survivor, right? But in tenants in common, now we distribute this to this person's heirs. Not the most common form here. There can be some pros and cons to putting things in tenancy in common.
That asset gets chopped up into smaller and smaller pieces.
They're actually co-owners.
Yeah, right.
We have co-owners. This is still one piece of property, and we now have 3 owners in unequal shares.
We have a situation where there's like 16.
And for any of you that tribal trust land, this is how it was set up back in like 12? And now we are 5 generations down, and many of those were large generations. We had some Native American students pull their reports, and we're doing research. You know, one of them owned 1/256th of a 40-acre parcel. I mean, it's a
And
mess.
if you want to make any legal changes, everyone has to sign off.
Yep, and yeah, so the BIA manages it when there's not enough, and of course they haven't done a great job either, but you can't pledge it for collateral to build a house. And you also don't own, 10% of the corner, you own 10% of the whole thing. So be glad you don't own reservation property, right? Because this is essentially, fast forward this many generations without much estate planning, and that's the situation it's on.
So it's like you don't know anything.
And you'll get like the students we had do it, BIA manages this, because there were so many owners, right? So once there get to be so many, if you want to lease it to graze your cows, you talk to BIA, and then they distribute the revenues to the owners. But the one kid gets an annual check for $7.04. Right?
That more money.
And they actually hold it until it gets to be $50, because they keep it in a little account, because they don't want to write checks for $3.09. So, but this is one of the challenges of owning property. And generally, only tribal members can own that type of property. There's a few exceptions. And most of those exceptions are up north of town here on the Salish Spooky Reservation. So.
What do you mean, this only happens to Indians? I mean, couldn't this happen to?
So this certainly could, right? You could have, tenants in common is very rare on the reservation.
No,
So
but because of property, we have farm property.
Mhm.
That's the 3rd generation.
Yeah. But most of it was owned as joint tenancy. So it may be broken up in a 40-acre parcel, but you own all of the 40-acre parcel. We don't see as many fractionated ownership. It may have been 160, but it got divided. But you own all of, say, 40 acres or 20. You have some tenancy in common.
And then if you want to do anything legal, everyone has to
Yep.
sign off on it. And if one person won't pay their little fraction of
Yep.
tax, everybody else has to pay it or you'll lose it all.
Yeah. Yeah, and that's one of the reasons we don't see a lot of voluntarily putting land into tenancy in common, because there are some things where it's really helpful, but there's many situations where it creates more hassles than the benefit you get out of it. But one of the things with the Indian land is you can't take it out of tenancy in common. It's permanently stuck in. Now, you can still do estate planning that would say, give all of it to say this child and none to this one. Right? Which would prevent further, but.
Yeah, the Indians can do that, right?
Good. Yeah. And they could sell, this child could sell his quarter to this child, or to this up here. Those things can happen. But you know, like these tribal reservation kids, what do they care about this 156? Nobody asks them to buy it. They just get their $7 every year. And it just sits. And they don't, like, when they're doing estate planning, what do they care? It's a thing that generates $7, so it's not even a concern. Actually, they did some American Indian Probate Reform Act about 7 or 8 years ago, which made it easier for current owners to buy out other small owners. So let's say I own a quarter and there's 250 people that own a bunch of the rest. Basically, BIA can say if you make a competitive offer, they have to accept it. So that's been a tool that's helping to slowly.
So is that only for Native Americans?
That particular piece, yeah. It was specific to the Native American piece, just because the problem is so much larger there. Not that it couldn't happen elsewhere. But. Okay, so other questions about property ownership, and we'll talk about some of the tools we can use beyond how we licensed our property. Okay. Contracts. Another type of contract is life insurance. Okay. Everybody has a life insurance policy. You probably had some big paperwork thing you signed, right? That's another form of contract law. So let's talk about what happens to life insurance. So Bill, we're going to say, has $100,000 life insurance. Designates Mary, his wife, as the beneficiary. Okay, pretty typical. Right. Then he decides, you know, I'm going to write a will. My son Chris is going to inherit it. Okay. So, who's going to get that $100,000? Mary, she was written on the beneficiary form, or Chris, who was on the much more recent will that he wrote. Okay? Who's going to get it, Mary or Chris? Yeah, it's going to be Mary. Contract law is going to take precedence over the will, even if the will was written more recently. Okay. You probably also have beneficiary forms on things like your IRAs. If you have a 401k plan, 403b, pension, 457, all of those type of things have beneficiary forms as well. So it's a good opportunity to check and see who you put on there, especially if you've had new grandkids added, new kids, new spouses, any family changes, people have passed away before you. Great chance to go take a look at the beneficiary forms. You can always file a new one that will override the old one.
So, I'm sure my beneficiary is my wife, all of that stuff. Since she died, what happens?
Okay. You may have had the opportunity when you initially set it up to pick what's called a successor beneficiary. So if I pass away, Ben's going to get my stuff, but if Ben's not living, Jim is going to get it. Okay. So you may have already, and that form is still just fine, because if I were to pass away and they go to distribute it and we call Ben, oh, Ben already passed away. We go down the list and we say, oh, Jim's not here, he's next. Okay. So when you set it up, you may have listed all your kids, your grandkids, your brother. Right?
So isn't that just kind of on most forms?
It is on most forms, yeah. But sometimes they don't, well, they usually want you to put a beneficiary down. They don't necessarily, if you mail in a blank beneficiary form or don't return it, they might call you and say, please fill out the beneficiary form.
Well, a lot of times they require social security numbers and you don't know them.
Yeah.
So then you have to get them and then send them back.
Because they want
So
to
if you don't
know
do that,
which
then you don't have one.
which John Smith that you want to give it to, right? So sometimes they may ask too, how is this person related to you? It's not that they care, but they want to be able to track this person down. So yeah, they do commonly ask for social security numbers, sometimes addresses, sometimes a relationship to you. And what they're really trying to do is figure out a way to find this person in 35 years when you pass away. And the last thing they knew about it is his name was John Smith in 1973. But But if you fill it out and you don't fill out successor beneficiary forms, they probably won't mail that form back to you. They'll say, okay, they picked one, fine. So it's kind of up to you. You can always call all of your providers, or if it's through your workplace or something, ask them. You know, and they will always, even if they can't find your original, give you a new one, and you can file one, which will take the place of any previous one that was filed.
Well, if they can't find it, how would they possibly email
So they may find it later.
When they like list things in the newspaper.
Yeah, so sometimes, you may have seen one, so the state of Montana sometimes, or different insurance companies will have people they can't find, and they know there's property there. And there's a process where, so like I used to run retirement plans, and we'd have somebody, usually happen in our case, where let's say a small company got bought out, so now we're closing the retirement plan, and we're giving everybody their money back, okay? But somebody quit working there 12 years ago. And last we knew, they lived on First Street, and when they quit, they sold their house and moved. So there's some process, there's some companies that help track it down, but after we had done certain steps that were laid out, then we could actually turn that account over to the state. It's still in that person's name. And then if they went looking for it, one, the state usually publishes a list, you see it in the newspaper every year. If anybody know Bill Smith, there's property missing, you should contact the Department of Revenue, right? So most states have a program like that. Because what that let us do is, otherwise we couldn't close this plan, you know. We didn't want the money, we wanted to give it to, but they will hold it permanently in that person's name, or at least for 10 or 20 years, I forget what the state rules are. But they've got it, and then if John Smith comes back and says, hey, I thought I was beneficiary on Bob's life insurance, they can call the state, and the state will say, oh yeah, MetLife turned over to us, $912 on 2008 in your name, and yes, we are happy to return it to you. So a lot of time and effort is spent by especially retirement plan companies looking for people with small account balances. So if any of you have left a company and they say, please open an IRA and take your money, that's why they want you to take it, right? They don't want to be tracking you down for the next 35 years. They'd rather give your money to you. Okay. Anybody that's worried about minimizing their probate estate, things with beneficiary forms do not go through probate. So the estate may still be in, parts of it may be probated, but these pieces do not need to go through probate. So if you write on there that, you know, my son Bill is going to get a life insurance company with a copy of the death certificate, you can typically distribute directly to those folks. This is oftentimes one of the reasons people don't put my beneficiary is my estate. See some people like that as their beneficiary. Because then it moves it into what could go through probate, and it gets a little bit messier to distribute. So it can be done that way, but a lot of times people don't do it that way because it's simpler to settle your will or your estate if it's directly named on there. So there's other things. You can't name a beneficiary on your savings account, but you can name what's called a payable on death designation. Okay, these did not always exist in Montana. I think it was in the early 90s these came around, something like that. Essentially what you can do is it's just like a beneficiary form. Okay? So when I die, pay whatever's left in here to, you essentially list a beneficiary. So if you set up your checking or savings account in the 1970s or 80s, or aren't sure, again, you can go down to your bank or credit union and you can ask them, can I fill out a beneficiary designation on this? And you can name whatever beneficiaries you want. Okay? And that's on basically any type of bank account can have a payable on death. Now, the same thing is true, this is just what it would look like. You see POD written a lot, where we had Jane Johnson, payable on death to Bill Williams and Donna Smith equally. This is also where you could designate tenancy in common, or they can split. If the bank account, they can split it. You know, there's $10,000 in there. If we said equally, they'll create a new account, $5,000 for each.
So, if you have a will, is that a bank account as a contract thing, I guess?
So you don't have to name a payable on death thing, right? So a will, if we did not have a payable, if we have a payable on death, the will is not going to apply to that account. Because this contract will override anything that's in the will. We could not put a payable on death designation on, and then if you had a will, the will could direct where this money
Oh,
goes.
so that if it's going into your estate, then it'll just funnel in there with all your other stuff.
Might go through probate though, which could be a little bit trickier, but it might not be a lot trickier. I mean, probate, it's a bad word, but parts of it are.
But if you name a person, like if you wanted your money to go to your 3 kids, and you just name one person who's
You
going to
could
be the
name 3.
executor,
Oh, so if you name one, you're executive.
then
you
they
get it
will
all.
get it
Yeah.
personally.
But you could name all 3 of your kids. Or the 2 you like.
And then the other one is never gonna like him again, so that'll be a bad.
You want, right. Yeah. You can also name things like a charity here. You know, you could direct it directly to something like that. You know, it doesn't have to be a person, I guess is the point I want to make there.
So this equally, is that joint tenancy or is that tenancy in common?
So equally, what this typically means is they're going to actually split that account in 2 pieces. There's $10,000, you're going to get an account for 5, and I'm going to get an
That's
account for
tenancy
5.
in common then, more or less. Huh?
Well, no, it'd be sole ownership twice.
So, I see.
See, because if you could say this is going to be Bill and Donna Smith, joint tenants with right of survivorship, I could direct that, right? But as a joint tenant, either one person could go in and withdraw the whole thing, right?
I guess so.
So generally, you don't see where they specify joint tenancy because that's probably not what you wanted. You probably wanted both people to get it. So by putting the word equally, now we've got away from this, that, you know, okay, we set it up in our names, but I got to the bank first, so I withdrew it all. Right, and that would actually be legal. Might make family dinners a little more interesting, right?
Yeah.
Again, you can specify how people get it, so. You know, if you're giving it to your son and daughter-in-law, maybe specifying joint tenancy is just fine. If you're giving it to 2 siblings that, you know, don't live together, maybe that's not the right thing to say. And this equally generally means you're gonna, the bank will go in and separate it into 3 separate accounts, and they'll have sole ownership of that, so. Again, it simplifies things if it's not going through probate. It's usually a quicker and easier settlement if you've done this. So that's sometimes a reason that people would say, give it equally to their 2 kids via a payable on death rather than, my will says each kid gets half anyways. Right? So that's one reason to put it in, is it just helps simplify the process.
How about like on stocks and things like that?
Perfect.
Oh,
Transfer on
another
that.
nickel.
I should have bought prizes.
I just went through this.
Uh-huh. So this essentially works exactly the same way. They call it a transfer on death, and this is for securities. So this would be your stocks, bonds, mutual funds. And again, with this, you can do the same thing. You know, checking accounts are liquid, right? They're essentially cash. With this, the actual asset doesn't necessarily have to sell. This can be sometimes important on basis and things like that of a particular individual stock ownership, where if I sell it, or if it's you see it sometimes with family farms or those corporations, it lets them transfer those things without having to sell and value and then repurchase. They can actually just say, okay, these 6 shares belong to you, these 6 belong to you, and they just transfer the ownership, as opposed to selling and repurchasing.
When they upped it to 5 million, did they also up the basis where it's transferred at the higher amount?
Yeah, I don't think I put any slides in on basis, but for those of you that are familiar with basis, so when I buy, let's say, a piece of property for $100,000, and it's, assuming it's not a home, 10 years later I sell it for $200,000, I say, let's do $300,000. So I have a gain of $200,000. That's called a capital gain, and it's taxable at a rate that's generally 15% right now. Okay, so my tax, if I would have sold that for $300,000, would be $30,000. $200,000 times 15%. If I had died and given it to my daughter, and she turned around and sold it the next day because she had no interest in it, her basis bumped up to what it was the day I died. So then if she sells it, there's no capital gain. So that's oftentimes why we see, maybe Forest is true, I'm not as familiar, but certainly on farmland side, we may have given the whole cattle operation over to son and daughter-in-law who's running it, but the land is still in grandpa's name. Because when grandpa passes away, basis is gonna jump up. Now they get it. If I had gifted it to them, they keep the basis in it that I had. If they bought this in 1970 for $10,000 and now it's worth 200, if I give it to them, their basis is 10,000. And if they had to sell it, they're gonna pay a capital gain on that 190,000. So that can be a reason sometimes where land, sometimes stocks, shares that have basis in them. People don't gift them, they wait, or sell them prior to death. They wait until they pass away to transfer those assets.
But if you have, say, property with joint tenancy, when one of them dies, you only get half of the stepped-up basis.
I don't think the basis steps up, I'm not
Yeah.
sure actually.
Yeah,
Is that what it is?
so you have
Okay.
to start calculating everything
Partial
on two
basis.
different bases.
Yeah.
So which is why some people do sole tenancy
Mhm.
with,
So
right,
that,
so that you just get a complete stepped-up basis.
and I know back in the 80s, we used to see a lot of farm corporations were created that held the land, but a corporation never dies, so the basis never steps up. So now, with current tax policies, we rarely see corporations hold the land. We almost always see them in, even if the individual owns it and rents it back to the corporate farm they're working on. But then the basis can jump there periodically, so, and tax laws could obviously change over time, but we see some different tools.
Hasn't there been some discussion about changing that step-up basis, eliminating?
I've heard various, the capital gains in general, you hear discussion about from time to time, but I don't know of any specific proposals at the moment, but yeah, it could change tomorrow. Congress can never agree what day it is, right? Once they get that, they can move on to the next one.
This is particular to me, okay, so my wife and I are in trust and she dies, what happens to the basis?
So probably that trust isn't fully funded until you pass away. So
Me?
then it may be allocated to the trust, but probably when you die, that's gonna be the formal step up of basis points.
Just my basis, I mean, when I die, the whole thing goes up to the.
And if some of it was in your wife's name, some of it may have jumped when she passed away, depending on how you had things timed.
That's how it happened with my parents.
Yeah.
Mom dies, everything was in the trust, no change.
Yeah.
Dad still had it. Dad dies, the trust kicks in, the basis is already calculated.
It depends on how you funded that trust on the timing, but that's usually what happens. It depends on the ownership of the particular asset, if the land is, some property was only in Ben's name when mom passed away, nothing happened in that case, even if that was going to funnel into the trust later. But if it was in joint or she had sold,
We deeded to the trust. So the whole thing's in the trust.
you can certainly check with whoever set it up for you, but my guess is your basis is gonna jump up. Either at the point when, either a blend of when the two of you passed away or when the later passes away.
So like if something is in a trust and he wants to sell something, he gets half a stepped-up basis, or where,
Depends on how
or
it's
has
put
the
into the
basis not
trust.
stepped up
Depends on
enough?
whether it was irrevocable trust or revocable trust.
Yeah.
And it gets a, that's why trust, we can spend hours on it, but,
Yeah.
your
What
trust
do you mean, so if I
agreement.
sell it, it's different than if I
Revocable
die.
until he dies, but after he dies, it's irrevocable.
Yeah, and sometimes they're revocable up until then, but there are trusts that are fully funded and things have fully been transferred before someone passes away, and there's nothing been, Ben gave his land to certain irrevocable trust, it's a done deal, even if you change your mind. So a lot of times we see trusts that are set up as revocable, and they're not funded until the death of the people who are trying to set them up, usually the same mom and
What
dad.
does funded mean?
They don't actually own any assets, essentially they exist on paper.
Oh,
So they exist on paper, they're sort of a shell waiting to collect assets. And when mom or dad dies, so all of a sudden assets come in, and the rules of the trust have already been drawn up in advance. And that's when it's funded.
So we recorded these things, so we must be funded, huh? Is that true?
Not necessarily, you may have recorded all the rules for them, you may have funded it. But it may be set up so that when you die is when it funds and then it does what it's supposed to do. I mean, it's all paper. If you had an attorney help you set it up, I'm sure they, set it up. So it's accomplished what it is you want it to do. But they can be set up either way, so. Okay, so there's those, let's see. Real property. Okay, how many people have a beneficiary deed? How many people use the word beneficiary deed in a conversation? No one did, right? Okay. How many people bought property in the last 10 years? Buy any property in the last 10 years? Okay. So beneficiary deeds were not always allowable in Montana. They're essentially a lot like a payable on death designation for real property. Most notably land, that's what we're really thinking about here. And if you were to go buy a house today and you get a mortgage, you know, you sign your name 45 times in this huge stack of papers, chances are one of those is going to be a beneficiary deed.
What is it?
They're going to pre-prepare it for you. Essentially, it's like a payable on death designation for your property. So it can then be distributed to your beneficiaries without going through probate. If you own property and you don't have a beneficiary deed, you can go file one with the recorder's office in the county where the property is located. So if you own property in different counties, you might have to go to different courthouses. But it's a form, and essentially it's like a beneficiary form. Now, so this is a way you're going to essentially pick a beneficiary for that property. And again, it could be more than one. You could say, my 3 kids with joint right of survivorship will own the house, or tenants in common, or sole ownership to Bill. Okay, just like any of your other ones. It's going to avoid the cost of probate and that process. Okay. But one thing to note too, if you wrote a will, you said, my 3 kids are going to equally. And then you decide, well, the house is going to go to Bill because he's the one that wants to live here, and I'll give the other 2 a little bit more of this, so it's kind of equal. So what if we think about that, but then we write a benefit? So you got your will all set up, right? But then we give the house to Bill on a beneficiary deed. He gets all of it, right? And then the will isn't going to deal with that anymore. The will's just going to distribute the other assets. So if you file one of these after you've done a will, you might want to make sure that it still jives with what you're doing in the will, and you didn't change the overall allocation by doing some of these things. So anybody can file one of these if you're the owner for your property, okay? So what are the rights of this beneficiary, the grantee beneficiary? None. Okay. It's like being named a beneficiary on a life insurance policy when the person's still alive. You don't have any rights. Your name's on a piece of paper at the courthouse. You may not even know it. Right? I can't use this collateral. I can't sell it. I can't do anything with it. Okay. Grantee beneficiary could be a charity, a nonprofit, a person, a corporation, any of those things. Any entity can be listed. Right? And then we're going to file it down at the clerk and recorder's office in the county where that property is located. If you got out-of-state property, they may or may not have beneficiary deeds. Not all states offer them. Okay, so if you own, somebody said they had property by Spokane earlier, right there. I don't know if Washington has them or not, but Montana does have them. They've probably been around about 15, maybe 18 years, something like that. The legislature put them in.
So you said, what's the grantee? The grantee beneficiary is the person who is the beneficiary.
Yeah, they're the one that's going to get it after this. Yeah.
So if you purchased property in the last 10 years or so, and you look through it, it probably has that in
It might have had this in there. Yeah.
Might.
If it has a mortgage.
Yeah, well,
Doesn't
even if
it?
you did the title, it depends on how it was set up. You know, when your title company prepared that huge stack, it's pretty common they'll include it in there. And, you know, they did when I bought my house 8 years ago. It was in there.
Okay.
And you don't have to sign that one. And typically they flag it that way. You know, they have all the little sticky notes, you know, arrows, right? I'm sure everybody read all the pages, right? But if you're unsure, one, you can look at your copy of the packet.
Right.
Because I know everybody's been dying to do that. Get that out. You can also, if there's one filed, or if there's not one filed, you can go down to the clerk and recorder's office and file a new one if you want. And that certainly would eliminate, a newer one will always replace the older one. So if you want to change how it was done, update it, you can do that. So, and you need one of these for each piece of property. So if you own forest land, but it's 7 different tracts, and they're all titled separately, we file 7.
Wait, say that again?
If you know, your forest land, you probably have titles, and it might be that 160 acres is one piece, and 32 acres is another piece, and 48 acres is another piece.
But it's all connected?
Might be, might not be. but you may have a separate title for each of those different pieces of property. Or if you live in a house in town, if you have, if technically your yard is a second lot, you own two pieces of property, then you would have to file two, one for each lot. But certainly with farmland, I know we see a lot of, I got a 320 acre piece, and then I got a 160, and I have the other 160 that goes with this one, but that I have three titles. So you'd file three of these.
So if you put your three kids' names on that equally, then what happens if you die? Do they each get a third of?
So again,
third,
you
or
could-
do they join it, own it together?
You could designate how they get it. You could put joint tenants with right of survivorship. You could put tenants in common on there.
Oh, you have to decide.
I got a question. You said before death of the owner. Suppose you have one of these things prepared and then you die and you didn't get it recorded. Is this thing any good?
If it hasn't been filed with the clerk and recorder, it wasn't done.
Didn't happen.
It has to be filed. It's not effective until the clerk and recorder has this piece of paper.
Even if you can wave it around.
Now, you could have a will that had done the same thing, but it would have to go through probate, which might not be too big a deal, but there's other ways to transfer. This is just a tool they gave that's a little bit simpler way sometimes.
So unrecorded is just no good at all.
On a beneficiary deed.
Yeah.
Beneficiary deed, if you print this form out, you can fill it out, put it in your safe deposit box, and it doesn't mean nothing. You have to file it. Okay. I think I already mentioned that. Let's see. What happens if the grantee beneficiary dies before the owner? You can, they call it
File a new one.
successor. Yeah, you can certainly file a new one, replace that form, right? But if this is the way, and it's very much like the life insurance beneficiary, you can name your son as the beneficiary, your grandson as the successor beneficiary. If the son passes away first, it would be this. In the case of the son predeceased, dad, in this case, it would go directly to whoever you designated. So in this case, the grandson. So again, you can have multiple layers. So my husband gets it all, but if my husband dies before me, then it goes to my kids equally. That's probably the most common thing we see. All right. Any questions on that? Okay. I think we've already mentioned this. What about a beneficiary deed if you already have a will? Okay. Father files a deed, and his daughter is the beneficiary. Okay. Then he has a will that decides to give it to his son. Now dad passes away. Oh, I guess I'm going to let you vote here. Who's going to get it? Linda, the grantee beneficiary, or Matt, who was named in the will? Yeah, and it's going to be Linda. Okay, that contract law is going to override the will every time. So this is a contract. Yeah, it's just kind of reinforcing that as well. The beneficiary can't be revoked by will. So wills are great, but just remember, if you've controlled something already via a contract, your will's not going to have any effect on anything you've put a contract in place on. Okay? That's one, yeah, so this again just saying you can designate more than one person. So this is also a good reason if, when you wrote your will, especially if it's a little bit dated, maybe it was before beneficiary deeds were allowable in Montana, to now file one may alter what you originally intended to do in your will. So if you're going to file one of these, it's a good chance to take a look at your will and make sure that everything still jives with where you want it to go. And does, if you say in the will, everything I got gets split equally money-wise among my two kids. And then you file a beneficiary deed on your house that gives it to one kid. One kid now gets the whole house asset and half of everything that's left. So then your total is not going to be 50-50 anymore. So anytime you make updates to your plan, make sure it still jives with the other pieces. If you file more than one of these, the newest one is what's going to apply. And the clerk and recorder records these. They've got a file for every piece of property in the county. Martin, the other one, replaced by subsequent deed, and they'll have the new one on file as well. How we doing on time? Oh, we are essentially out of time. Okay. Questions on beneficiary deeds? Questions on other things we didn't get to? Trust, I didn't even put those slides in.
He was never gonna go.
Do you have
there.
You know, on the Solid Finances website, I think we've got one that talks more about trust. Trust tends to be kind of,
We have one of those too.
you bet. Yeah, and there's plenty of these for everybody if you want here. That's kind of level 10 of estate planning, and we most often get to do level 1, 2, and 3 over and over again. So I don't know if we've recorded that one. There is a mock guide on one of the trusts, and bypass trusts are in there too. So it'd be a couple of resources I'm pointing towards. Anything else?
Thank you, that was very interesting.
Thank you.
Thought provoking.